your I-130 is approved, but not the I-485. You might have a situation where you might be thinking like, why is my petition approved, but not my 485? Okay, so the first thing about this is that I think someone had talked about this just yesterday, possibly, but we just happened to have this as a topic today. Yeah, yesterday, the person, if I remember, he or she did not know, was not aware that they had a court case, removal proceedings that had ordered them removed. And that's because they didn't have the address, which makes sense because if you didn't have a case on file, you wouldn't have an opportunity to basically provide your address, update them. And if you have, so typically when you have an I-130 approved, you might be wondering, why is my 485 not approved at the same time? Typically, that's because USCIS sees in the system that there's a court case, a case in removal proceedings, whether it's still open, existing, or administratively closed. It wouldn't be dismissed because if it was dismissed, that's actually what you're looking for. So the person yesterday, he or she had that case that was closed, but in the sense that it was ordered removed without their knowledge. So we had to file a motion to reopen based on lack of notice, for example. It's not always the same reason. It depends on your scenario, your situation. But that's a typical situation when the I-130 is approved, but not the 485. Because if you were to have an interview, which is typically the default, by the way, we are in a 2023 trend with USCIS that they are waiving interviews. Number one, that's typically for marriage cases. And number two, is not automatic for everyone. It does require, of course, for us, fortunately, we've been successful in getting these interviews waived because we rely on our proven checklist and our clients follow it. And number one, I can tell you part of what it is that you need a bank account that you have both names on it. Okay, you need to allow access for your spouse because in the government's perspective, if you're not willing to share access to at least one bank account, doesn't mean it has to be more than one or all of them, at least one, then it conveys to the USCIS that you care about each other, that you want to live a life together because you want to share your bank account to the extent that the other spouse can use it, can withdraw money. Not saying, hopefully, knock on wood, withdraw all the money out, but that both spouses have the ability to withdraw and deposit money. And by the way, you do need to use it, okay? We've heard of people, they open it, share it, and they don't use it. The whole point is that you have to use it to share statements that shows your transaction activity, deposits and debits, credit and debit. And now I'm going to get to what you need to do on that, okay? So you might need to file a motion reopen if there is a court case. That's typically the scenario when they only approve one. But then you might think, well, why even approve the I-130? Why do that? Because 485, when there's a case in court, that's where the 485 gets stuck because the 485 application is for the resident status. The I-130 is to establish your legal relationship. So in this sense, like let's say a marriage, because if someone, I remember a pro bono case where many years ago, the person was serving in the military, a veteran, and so we picked up the case and helped him out. And he was in a different country serving in the U.S. military when his spouse filed for divorce. And so he signed some documents, right? And he thought, and I'm assuming he signed a waiver of service. I didn't go into that detail. And he thought it was done. He probably didn't pay attention what the actual document was that he signed. Otherwise, he would remember. But it likely was not the divorce order. He likely signed the waiver of service. So every state is different, but more or less we have similar documents in that sense, the titles. So he thought the marriage was over, that he was divorced. So he got married to someone else, filed for a green card. So that's another scenario. But the petition would get denied in that situation. And it was for him because he thought his first marriage was complete, was divorced, not complete, that the divorce case was complete, but it wasn't. So and USCIS found out because ultimately they asked for the divorce order. So that's an example where the I-130 petition could be denied. Don't wait. If you're in a situation and you find out, whether through the USCIS officer or through other means, that you have a court case, do not wait.